the federal indictment. And again, this is a federal indictment. It is not done on a whim. That's one. The other, Your Honor, is that my client will be testifying. If not, I can just very briefly explain it. But he'll testify is that he had a game room, and that within about 3 or 4 months it was shut down. And just across the street, they continue. They've been years open, and so we went ahead and said that, why are you allowing certain ones and not others? The district attorney decided to recuse himself because we were accusing him of basically favoritism, and decided who to be open on game rooms and which wouldn't. And he will be able to tell you that story. But I don't think the court needs to go through the whole story. That's basically the argument that he will be saying that it already happened to him, where he realizes that it's a favoritism, and certain people get certain benefits, others don't. And so the whole office of Mr. Guerra on that particular case recused himself. And so that's all for Your Honor.
All right. Anything else?
No, sir.
Sir, response.
Your Honor, just briefly, we have not, Mr. Villalobos has not been formally served with any type of copy of the petition for removal, not even a courtesy copy from the petitioner. This court did enter an order, I believe it was last Saturday, setting this hearing, ordering the clerk to provide a notice to the parties. We did not receive formal notice. We found out about this hearing through the media. We are here nevertheless to proceed if the court wishes us to be here to proceed. And we have filed our objection or our brief in response for the court to consider as to why this court should not issue citation. And Judge, just briefly, we do cite several cases in here which indicate that from the inception of a removal proceeding, the presence of the state as a party is a necessity. And we cite 2 cases here, Garcia versus Lawton, which is a 1955 Texas Supreme Court case, and In re Wolf, which is a 2011 Texas Supreme Court case. Both of those stand.
Do you have copies of those cases with you?
I do, Your Honor.
I read the Garcia case before, but I did not make a copy of it.
Case, the Texas Supreme Court case, the Texas Supreme Court said that the joinder of the state was a necessity, and without the state being petitioning party, the trial court lacked jurisdiction to proceed. In Wolf, the Supreme Court said basically the same thing. However, Wolf is a little bit different because in Wolf, what the Texas Supreme Court said that you couldn't even do that. You couldn't even get to the point of doing pretrial discovery. And so we're at the point now, Judge, where a petition for removal has been filed. We're here before the court, and the state is still not a party. The county attorney or the district attorney from an adjoining county has not been, is not a party to this suit. And therefore, with all due respect to Your Honor, we believe that this court is without jurisdiction to proceed, to issue citation, or to do anything other than dismiss this cause. Judge, additionally, and alternatively, we've cited as a second ground in our brief in opposition that the petition for removal is deficient. It doesn't meet the interpreted that to mean that the petition must be sworn to positively and unqualifiedly to be true and within the personal knowledge of the affiant, done by an elected official. And I'm swearing out a complaint telling you exactly what they have done, and then that is taken to the state. Merely states by the petition of an offense, he's lived within Cameron County for at least 6 months within the state of Texas. He's not currently under indictment, and that's it. He doesn't say anything concerning the allegations that are raised in the petition itself. There's no indication that he has any personal knowledge of any of these allegations. And as Your Honor is well aware, Mr. Guerra has attached a copy of the indictment. An indictment, as Your Honor is well aware, is absolutely no evidence of guilt. We instructed juries of that in every single criminal case that's tried in the state.
Well, that's in a criminal case.
Yes, Your Honor, that's
This
true.
is a civil case.
This is a civil case, and I would assert to the court that it's no different than a civil case. They're merely allegations. They're not proof of anything, other than the fact that the allegations have been made. But that's it, Judge. And so without something more, Judge, the statute specifically provides a mechanism for that. Chapter 87 of the Local Government Code provides that when the county attorney is the subject of a removal proceeding, then the proper party, if the court will give me just a second, I can give you a specific cite on that.
Yes, I have a copy of the statute. Yes.
Subsection E and F.
As far as you know, has Cameron County expressed any interest in selecting a county attorney from an adjoining county?
Not that I'm aware of, Judge. I know there was some conversation in the media by the county judge. However, there's been no official action.
All right. Now, with regard to the affidavit, it can be pure, can it not?
Yes, Judge. The Driscoll versus Lindsay case would seem to indicate that an amended verification would give this court jurisdiction.
And under the circumstances of this case, and reading only what has been filed, would it not be in the interest of justice to afford the petitioner the opportunity to cure a defective affidavit?
Judge, if this court otherwise has jurisdiction, because the state has been properly joined as a party, then certainly the court has that discretion. And the matter of determining whether that's in the interest of justice, of course, lies upon the court to determine that. Myself as an advocate, I would argue against that. But certainly that is a possibility if this court finds it